In early 2019, the United States Supreme Court released its decision in New Prime v. Oliveira, which was an important case determining the scope of the Federal Arbitration Act. The decision was a unanimous one and a bit of a surprise, since for probably the first time in almost 2 decades, the Supreme Court did not enforce an arbitration agreement. In fact, it expanded the list of individuals who would be considered exempt from compulsory arbitration under Section 1 of the Federal Arbitration Act, or FAA. So what does that mean for business owners and employees? Are arbitration agreements dead? Can employees trash their arbitration agreements and bring all their claims to court now? Not quite. I'm making this video to cover some important things you need to know about the New Prime case and what it means for business owners and employees. First, a little background will be useful. The Federal Arbitration Act, or FAA, is a federal law dating back to 1925 that enforces written arbitration agreements. These kind of agreements are popular in employment agreements, where most employers would rather have their employees arbitrate potential claims rather than bringing a personal or class action suit in court. Section 1 of the FAA provides some exceptions to enforcement of arbitration agreements, and it excludes transportation workers who are engaged in interstate commerce. That means these kind of workers are not bound by arbitration agreements. Now, in the New Prime case, Mr. Oliveira was employed by New Prime as a truck driver, initially as an independent contractor. With the way that New Prime was paying Mr. Oliveira, he found out that he wasn't being paid the minimum wage required by law, and he decided to bring suit as a class action. Well, New Prime had included an arbitration provision in its employment contract with Mr. Oliveira that said 2 important things. First, disputes between Mr. Oliveira and New Prime would be arbitrated, and second, if there was a dispute about whether a claim could be arbitrated, an arbitrator would be the one to decide whether the claim could be arbitrated or not. But Mr. Oliveira argued that he was an exempted transportation worker under Section 1 of the FAA, even though he was an independent contractor rather than an employee, and that as a result, he wasn't bound by any arbitration agreement. Mr. Oliveira also argued that an arbitrator couldn't decide whether he was exempt from arbitration, that a court would have to decide that question before any arbitrator became involved. These are the 2 issues that made their way to the Supreme Court, and the court sided with Mr. Oliveira on both issues. First, it held that it was a court's job, not the arbitrator's job, to decide whether exceptions to the arbitration requirements applied. Second, the court stated that a worker's status as an employee or independent contractor didn't matter when determining whether they were exempt from compulsory arbitration under Section 1 of the FAA. An exempted transportation worker was simply someone who was employed in interstate transportation, regardless of their technical employment status. Since the New Prime decision, some legal commentators have speculated that this case might be or become the basis for expanding the FAA Section 1 exception to virtually all workers engaged in interstate commerce. This would be a huge deal because based on Supreme Court jurisprudence, almost everything is interstate commerce nowadays. This would basically mean that the vast majority of workers were exempted from the FAA under Section 1, which would mean that most arbitration agreements couldn't be enforced. Justice Ginsburg, in her concurring opinion, even stated that in her opinion, the policy driving the FAA and Section 1 was to exempt many more employees than are currently exempted. The reality, however, is that New Prime is an important case, but not that broad of a decision. Some could argue that it indicates a shift in the way the Supreme Court views the FAA and arbitration in general, and they might be right, but that's just speculation. For the time being, New Prime's holding really only changes things for those involved in the interstate transportation industry. Are more workers now exempted from compulsory arbitration? Yes, but this isn't a case exempting all kinds of employees from all different industries, at least not yet. For the transportation industry, however, there are going to be some big changes following this decision. For transportation employers, independent contractors will no longer be bound by their arbitration agreements. For employers who relied heavily on classifying their workers as independent contractors to bind them to arbitration agreements, it's going to be time to find a new way to do things. It would probably also be smart to be ready to handle certain claims in court, since it's more likely now that employment disputes will make their way there. Having skilled legal counsel with experience in employment and business matters is going to be more crucial than ever. For transportation workers, now is a good time to get a refresher on your rights. If you were bound by an arbitration agreement, you might not be anymore. If you have claims against your employer you've been wanting to bring to court but haven't been able to because of an arbitration agreement, New Prime might allow you to do so. Here too, it's a good idea to consult with an experienced employment attorney who can help make sure your rights are protected.